Good morning and welcome to the Court of Appeals today. We have one matter on our oral argument calendar, State of Utah versus Daniel Johnson. Counsel, if you could please enter your appearances for the record.
Rachel Phillips-Ainscough for the appellant, Daniel Johnson.
John Nielsen for the state.
Great.
Is that Judge Nielsen or John Nielsen?
December 2nd.
Okay.
I was like, oh, taken
This
aback.
is my last one.
Well, let's hope to give you a good one. Both sides, I think, are familiar with how our clock works. 15 minutes for each side to make their argument. It looks like, Ms. Ainscough, you have reserved 3 minutes for rebuttal? Is this your first oral argument, or? I have yet to have the pleasure of having you in court.
That is true. This is not my first oral argument, but it's my first one with you.
Well, welcome. Nice to see you. 3 minutes for rebuttal. The only thing I would remind you of is to enter your appearance every time you take the podium, because we are streaming and recording, and that just clarifies for the record who will be doing the speaking. If you have no questions, please begin.
Okay. Again, Rachel Phillips-Ainscough for the appellant, Daniel Johnson. The district court abused its discretion in denying Daniel's request to instruct the jury on self-defense. The Utah Supreme Court has stated that a defendant's burden to demonstrate that the factual record supports an affirmative defense is relatively low, and only a minimum threshold of evidence is required to establish the affirmative defense. And that's from the Arriaga v. State case. To the extent that it was unclear in Daniel's briefing, this court has determined that a court need not instruct the jury on the requested affirmative defense where the evidence is so slight as to be incapable of raising reasonable doubt in the jury's mind, and that's from the State v. Smith case. The state appears to acknowledge that the district court applied the wrong standard or an incorrect standard, but asked the court to affirm based on this so slight language from Smith and other case law. So looking at perfect and imperfect self-defense, that, again, the Utah Supreme Court in State v. Lowe stated that for both perfect and imperfect self-defense, the same basic facts are at issue. Indeed, a perfect self-defense and imperfect self-defense required the defendant to present the same evidence, that the defendant had a reasonable belief that force was necessary to defend himself.
Can I ask you about that?
Yes.
I mean, the standard, as we know, the standard is both subjective and objective.
Yes.
Right? Under the, sorry, I've lost my paper. Under the case law. And here, in this case, there was no recognition by the defendant himself. I mean, that was not his defense at trial. He stated that his kids were afraid, but his defense was that the door hit his hand and causing a discharge from the firearm. How much evidence is enough in the sense of, doesn't he have to have a subjective belief that he is seeking to defend himself?
Yes. So 2 points to that. So you're exactly right. So he did testify, or either through his testimony or his statements to police officers about son and daughter. But Daniel himself explicitly stated that he was scared of Steve. On page 2577 of the record, he said he was scared of Steve because of the way he was presenting himself. As you already acknowledged, that he testified, or at that time it was in his police interview, that Steve scared the hell out of his kids. Again, on 2577, he said the degree of anger was unusual and that he grabbed his pistol because he was scared of Steve. So I think Daniel did make these subjective statements. And I guess the second point I would make to that too is that while he talked about his statements about the door hitting the gun and it going off, he also made statements that he, let's see, on page 2580 and 81 of the record, he talks about how he did not remember hearing or seeing the gun go off. On page 2588, he says, again, states that he did not recall all the details that happened. And on 2588, during his rebuttal statements, when asked if the gun went off when it hit the door, he says, "No, I imagined I squeezed it." So there was testimony and evidence presented about Daniel's subjective belief that he, not only his kids, but that he was scared of the situation.
But in order to get an instruction, there has to be evidence that the force is necessary to defend against the imminent use of unlawful force or force necessary to prevent death or serious bodily injury. And how much credence, I mean, the trial judge is sort of acting as a fact finder in this situation, right? How much credence is there any sort of presumption that the giving the instruction goes in favor of the defendant, right? Like a presumption, like at a preliminary hearing, that all inferences go in favor of the state. Is that something similar here?
I think unless I'm misunderstanding the question, again, going back to the court is obligated, we cited that case law in our briefing, that the court is obligated to give the instruction to once the defendant has requested, if there's any reasonable basis in the evidence. And as I quoted earlier, that is a relatively low burden on that. And so if I'm understanding your question, that would be my response.
I mean, I guess the question is so the son in his CJC interview mentioned that he thought he saw the victim try and get into the house, right? But then there was also information that, maybe son wasn't particularly credible given his bias in favor of his father, right? So in making the decision about the reasonableness of the evidence, how far does the trial judge go in making that reasonableness determination based on the credibility of the evidence that's been presented? Isn't that a fact finder thing?
Yes. Well, I guess to the point of it being a credibility determination, that is something for the jury. And here, again, going back to the standard of, and once the defendant presents any reasonable, or there's any reasonable basis in the evidence to present that, then the court is obligated to give that. And then it's up to the jury to determine whether or not they, exactly as you mentioned, whether or not they find that to be credible or his testimony or whatnot. But, and also in the case law that we cited in our briefing about how defendants are able to have multiple theories of a defense.
I'm sorry, the answer to Judge Forster's question, I thought you cited Spillers for the proposition that in considering the evidence in its totality and whether that provides any reasonable basis, that at that decisional point, the court is supposed to review the evidence in a light most favorable to the defense.
Yes.
Are you not? So you're standing by that?
Yes. I believe, yes, that is what we cited in the briefing. So yes.
Okay. I just want to make sure I understood your argument.
Yes, thank you. That there is that case law on that point as well. And
Can I jump in
Yes,
and ask
please.
a little bit about the subjective part of this test? So there's
Yes.
in terms of whether the reasonable belief standard is met, there's an objective and a subjective component. Right?
Yes.
I think everybody agrees on that. The question in my mind is what the subjective component is aiming at. Right? In a lot of cases, the defendant doesn't take the stand and testify and tell us what he was thinking. In this case, the defendant did.
yes.
And he got on the stand and took the oath, and he said, what I was thinking was I didn't mean to pull the trigger at all. Said it was an accident. So he's in his own words, his subjective intent wasn't to pull the trigger and shoot in self-defense, right? So if the test is we have to look whether he had a subjective intent to exercise self-defense, that's problematic for you. But if the test is something else, and if we only need to have subjective intent that he reasonably believes that force was necessary, sort of in the abstract, then I suppose we would have some evidence of that, given what he told the neighbor and some of this other evidence. So I guess that's my question, is what does the subjective belief go to here in terms of what we need to look at and see whether there was any reasonable basis in the evidence? Any reasonable basis for what, right? That's my question.
To support, and I would just point the court back to that statutory language about that, whether or not an individual reasonably believes that, as you've already just kind of quoted there, that force or a threat of force is necessary to defend against the imminent use of unlawful force. And to the points that you made about what Daniel said when he was on the stand, again, I would just reiterate that, but he did testify about being scared, and it was unrefuted and kind of undisputed that both he and the children talked about Steve's behavior when he was there, and that, again, Daniel said that he grabbed his pistol because he was scared of Steve. And so I think, again, that subjective element has been met here based off of the testimony and evidence that was presented.
Okay, so I guess the answer is, what I hear you saying is the answer to the question is, in order to get the instruction, you just have to have any reasonable basis in the evidence that he reasonably believed that force was necessary, even if we don't have evidence that he reasonably actually used force, right?
I believe, yes, that would be my response.
So the decision tree you're asking the jury to go through then is you're going to be running these two separate defenses. The first thing you're telling the jury is, look, this was a total accident. He didn't mean to do this at all, so there's no crime here at all. The second thing you're asking the jury to say, okay, well, if you buy the state's argument that he actually did pull the trigger on purpose, then we want you to believe that he did it out of self-defense because he had a reasonable fear that force was necessary, or however the statute reads. That's the decision you want the tree you want the jury to go through.
I think I'm mostly okay with that. I guess my only other kind of pushback to that would be, again, that Daniel's more of his equivocal statements of, yes, when he talked about it being an accident, but he did state multiple times that he didn't remember, he didn't recall the details, that he does say, like, that I squeezed it, and he doesn't recall it going off. So I think at that point it's a little different from, I think it was in the O'Leary's case where, there's kind of the defendant had stated no, never happened, and it was a bit more unequivocal, whereas here he gave these more equivocal statements. And so again, as the jury, as the fact finder, and looking at the credibility, it would be up to them to determine what they believed at that point. And
well, they obviously did end up believing that he pulled the trigger on purpose. Right.
And that would be, again, our point of why in this case the self-defense instruction would have mattered, as the jury was instructed on those two lesser included offenses, and that because they rejected that and found him guilty of murder, that they must have believed that he did that. And again, that the self-defense instruction, and maybe this goes more to the harm part of it, but it would have mattered in the jury's eyes had they been instructed, or at least influenced, right? That if they had been instructed on self-defense, that it would have made a difference in their consideration based on the fact that they found him guilty of murder.
Yeah, as I follow that argument, I just want to make sure I follow it. The argument is, well, if the jury decides that he pulled the trigger on purpose and doesn't believe him when he says he didn't pull it on purpose, then they would have another decision to make if there was a self-defense instruction about whether he pulled the trigger pursuant to this reasonable belief he might have had that he needed to use force. And they weren't asked to make that inquiry.
Yes.
That's your point, as I understand it.
Yes, I believe that is correct.
So can I ask you a quick question then about the 23B?
Yes, please.
You might have to remind me a bit about the progression of the events, but wasn't it not until the council was having the jury instruction conference with the court that the decision not to give the self-defense instruction was made?
If I'm understanding your question correctly, yes. So they had, throughout the trial, they had kind of talked about, jury instructions they were going to do. And I believe it was day 3, they kind of said, they were going through and, what instructions. And at that point, they talked a little bit about self-defense. And then at that point, the district court was a little bit more inclined to give the decision, or to give the instruction. But then the next day, after more presentation of evidence, that's when the official ruling came that said, no, I'm not giving this instruction.
So had the defense put on its case?
I believe.
Did the defense put on its case before the judge made the decision on the self-defense instruction?
Let me double check. I'm pretty sure, because The court made its ruling around page 2735 to 2770, and Daniel's testimony is around 25. And I know the transcripts aren't always in order, but and I do believe that the court in its ruling does reference like what Daniel had said. So I do believe, and that was kind of the difference of day 3, that the judge kind of said, I want to hear like what other evidence is going to be presented, and then after it had been presented. But I can definitely double check that, and if I'm wrong, I will let you know in rebuttal. But that is my understanding, is that after that had been presented, or I'm sure the state will let me know if I'm wrong as well, but that the court made that decision after.
After Daniel testified?
I believe so.
Or after the entire defense case was in? Or just after Daniel testified?
I think Daniel was
The last witness,
sorry?
the last defense
Oh,
witness.
yes, yes.
Was he the last witness?
I
The
believe
last
he
defense
was.
witness, and then
Yes.
there was some rebuttal.
Okay.
Yeah, and he was
And he
called
was to
on
rebuttal.
rebuttal again for some questioning, but I can definitely double check that.
So I guess the answer to the question is, at the time Mr. Johnson testified, the decision hadn't yet been made whether or not the court would give a self-defense instruction.
As standing right here, that is my understanding, but again, I will definitely correct myself in rebuttal.
Because that seems to make a difference in terms of your requests to have the 23B granted. In the sense that if the decision was made after all the evidence was in, right? There doesn't seem to be any effort on the part of defense counsel to highlight or emphasize the self-defense, right? So, okay, thank you.
And unless, if there's not, Judge Mortensen?
Just as to this claim of IAC for not objecting to the officer explaining how the safeties on the firearm worked.
Safety
Often
features.
when we're, what's that?
Safety features. It's not a safety.
The safety features,
Well,
whatever you would like to call it.
on my 2 handguns, they're safeties.
No.
I've spent hours and hours at a shooting range, and I have never, ever heard a range master say safety features.
Right,
it's
I
just
stand
weird.
corrected.
No, I just, seems kind of weird. Anyway, my question is this. Often we're kind of sitting as an appellate court wondering to ourselves, can we think of any reasonable strategy the council may have had for not objecting? And often we can see, well, it seems pretty apparent this is what council was getting at. In this case, council actually cross-examined this officer based upon his testimony, kind of in favor of the idea that the gun went off accidentally. If counsel does that, that seems to be a strategy to say, I'm not going to object, rather I'd like to cross-examine this to support my theory. That seems to be a reasonable strategy. How does that not completely do away with this idea of IAC?
You're definitely right, obviously, about the strategy point on that. And I guess my only other response would be that in this case, it was ineffective to do the cross-examination rather than object at that point to prevent the testimony on it. But I do recognize that it could.
Well,
Your
I guess if it's not going to, if counsel wants to put evidence in front of the jury on how squeezing, I think essentially squeezing the gun as it gets slammed in the door or whatever could result in the gun accidentally discharging. Who else was he going to use to put? It seems like that was his only opportunity. He's not going to put on.
Yeah, he did not put on a different witness. You're right.
So I'm just, if that's what he wants to get in, that seems like the best opportunity. I don't see how it would be ineffective to have that be your strategy.
And I would
Why
say
is that unreasonable? I just don't. That's what I'm having trouble following.
Yes, and I think that beyond the other arguments that we've made in our brief, I would just rest on that point, and I don't have an additional response to that.
Okay, thank you.
If there's not any other questions,
Thank
I'll
you.
come back for rebuttal. Thank you. I'll take my water.
May it please the court, John Nielsen for the state. I'll start with the self-defense instructions since that's where most of the questions came in. Counsel talked about the necessity requirement. So the Utah Supreme Court was clear in Sarbonne that it requires this subjective belief in the necessity of force. But there are two different subsections that apply in 76-2402 too. A is about non-deadly force, B is about deadly force. From what I'm hearing defense counsel say, it's okay enough if you have a reasonable belief in the necessity of force under A, but you have to have a reasonable belief in the necessity of deadly force because you're using here deadly force. There's no question because it talks about what force you kind of use. Are you going to use force that's likely to cause death or serious bodily injury, or are you going to use something less than that? And where B applies, and B applies here because there is unquestionably the use of deadly force, the defendant has to subjectively believe in the necessity of using that deadly force.
The situation I'm wondering about is if somebody grabs a pistol with the intent, they intend to grab it, they intend to brandish it.
Yes.
And that's their self-defense is I'm going to brandish this pistol. Not a wise choice, grant you. Not a wise choice to, rack it and get ready, because bad things can happen. How does that play into that? If their intent is to brandish it and their brandishing is meant to be defensive,
Yes.
but then it accidentally discharges.
Yes, there are actually three different categories where you fall in this matrix. So imagine you have three different factors or variables on a chart. That is non-deadly force versus deadly force, a death resulting, death not resulting, and intentional or unintentional use of force. This falls in that matrix on the intentional use of non-deadly force that ends up being deadly. And there are three subcategories under that.
Okay, say that one more time.
The intentional use of non-deadly force that turns up deadly. So if you're intending to use something non-deadly, you're intending to brandish. This was actually the factual situation in Mitchison. So this is the case that I cite for the proposition that you can run inconsistent defenses. There it was somebody who came out, he was at his girlfriend's house, he came out, he was brandishing a gun, and he claimed that there was a struggle over the gun and the gun went off. So anyway, that kind of fell into that very same kind of situation. So where you have the intentional use of non-deadly force that turns out deadly, there are three categories of cases from what I can tell. Most of these are outside of the state, but just to give the court kind of a broad overview and give context to my answer, which is a long wind-up, I apologize, but I think it's helpful. One is you have an eggshell victim scenario. So you use non-deadly force that wouldn't kill the person, so it doesn't fall under subsection B. It's not likely to cause death or serious bodily injury to most people, but it ends up being deadly because of a particular vulnerability of that victim. That's not the kind of case we have here. A second category is third-party harms. So a transferred intent scenario, you try to shoot the person who's going to kill you, but you end up shooting a third person. Some courts will say that's kind of a transferred intent scenario, or more like a Rube Goldberg murder. Think about Paul's graph, but it's a criminal case. You drop the fireworks, they explode, and they knock over this. So that's another kind of scenario where you see this one falls under a third scenario, which is what I call the accident with extra steps scenario. So I have two sites for the court that might be helpful there. Commonwealth v. Turner is a Massachusetts Court of Appeals case from 1987. The site on that is 506 Northeast 2nd, 151. And another one is State versus Callahan. That's a Washington Court of Appeals case from 1997. Site is 943 P. 2nd, 676. And what the courts say there is when you have this like lawfully brandishing but accidentally killing somebody situation, it's essentially an accident with extra steps claim. Self-defense might give a little bit of context to what the person is doing. It shows why they were lawfully armed or why they were lawfully engaging in the conduct that they were engaging in. But at bottom, it is an accident claim because that fills the gap between what the person was doing and what the result was. And what fills that is accident. So at bottom, this is a very, finally getting to the answer to your question. In essence, it is an accident claim. It is not a self-defense claim. And I think Turner and Callahan really illustrate that and help show
yeah,
the reasoning.
that's the claim that Mr. Johnson was making when he took
Correct.
the stand.
Correct.
But the question I had for the defense, and I guess I'd like you to weigh in, is they can run alternative defenses, right? He can stand up and say, yeah, this was an accident. But couldn't they argue during closing argument that if you don't believe that he had no intent to actually shoot the gun and hit him, then you should believe that he did so in self-defense because he had a reasonable basis to believe that force was necessary to prevent death or serious bodily injury because he was coming at him, he's a big guy, he's angry, all those things. Tell me what's wrong with that line of thinking.
Legally, there's nothing particularly wrong with it, though I would point out that, well, it's mostly a practical question of what's wrong with that. So that's why prejudice is the easiest way to decide this issue. There is no way the jury is going to buy self-defense where the defendant takes the stand and disclaims belief in the necessity of deadly force. Where he takes the stand and says this was an accident, and he...
Well, I'm not sure it's accurate to say he disclaimed belief in the necessity of force. He disclaimed that he used any.
Yes.
But I don't know that he ever said that force wouldn't have been necessary given that the other evidence that he talked about that the guy was coming at him.
I'll push back a little bit. I think we're talking past each other just slightly because we're talking about different subsections. He believed perhaps that having the gun was necessary. He did not believe that shooting him was necessary.
In fact, he specifically testified that he didn't mean to shoot him,
Yes,
right?
precisely. So you could talk about it. You know, he clearly didn't mean to use it, but he also didn't believe it was necessary. It was all an accident. And that is asking a lot of the jury to reject the defendant's own testimony at trial in aid of acquitting him. That's just not going to happen, practically speaking. Juries need practical explanations for things. This guy's dead. Why'd you shoot him? Well, I didn't mean to. That's a perfectly fine explanation, but are you sure you didn't shoot him because he was trying to get at you? No, I didn't mean to shoot him.
So as a practical matter, it would be maybe not legally impossible, but the way you see the world, practically impossible to run those two defenses at the same time in a case like this.
Yes. And I mean, what's impossible is getting to a reasonable likelihood of a different result for the defendant. You just can't prove prejudice under these facts. But I also like to push back a little bit.
That's why I'm trying to get a sense of what that closing argument would have looked like, right? If you had run that defense and gotten this instruction, yeah, jury, this was an accident. But if you choose not to believe it was an accident, and you have to get into the question of what the mens rea was when he pulled the trigger on purpose, please believe that it was self-defense rather than something else, right?
When I was a trial prosecutor, I was in a defense attorney's office once for a meeting, and that defense attorney had a plaque on the wall with kind of a humorous summary. It said, I didn't know the guy, I've never met him. If I met him, I haven't seen him in a while. If I saw him recently, I was nice to him. If I wasn't nice to him, I had a good reason. It was an accident. It just kind of went through all of those kinds of things. Yes, it's legally possible. Mitchison is clear. You can run inconsistent defenses, but it's not going to persuade a jury. It's going to undercut your credibility because you're not picking a horse and riding it. Now, again, there are circumstances where it's possible to kind of thread that needle, but this is not one of those circumstances where there's a reasonable likelihood that anything is going to be different. But I'd also like to push back on the idea that it was required in the first place, because the evidence really was very slight. Let's look at the two sources of potential evidence for a self-defense claim. One is the defendant's statements to his neighbor, Mr. Sims. It is entirely conclusory. He basically just said, my kids were afraid I had to do something. That tells the jury nothing about what happened. It's just kind of like, I acted in self-defense. And that's that's kind of what Son's testimony, or at least his CJC statements in lieu of testimony were. My dad acted in self-defense. Well, you need some detail. You need to say how and why.
Didn't also, though, the son
Yes.
state that he saw the victim, or his impression was that the victim was coming.
There was going to be a lunge or
There was
coming
going to
out.
be a
Yes,
lunge.
there was additional detail there, and I acknowledge that in my brief. I said
Yeah.
perhaps this might have been an imperfect kind of self-defense claim, but again, there's just no prejudice here, because where the defendant takes the stand and says what he said, they're just not going to, they're either going to believe him that it was an accident, or they're going to convict him. They're not going to say, yeah, we don't believe him it was an accident, we believe he did it on purpose in self-defense.
So my conundrum, sort of, that the trial court acted as sort of a fact finder in this situation, is not accurate. Like, it's not a legitimate conundrum. In a way, right?
It's a legitimate question, but I think under the facts of this case, it depends a little bit on what you see the test as being and what you see Maestas and Kell as saying. Because Kell was another case where the Utah Supreme Court said, yeah, there was some evidence of self-defense in the sense that Troy Kell said, I killed him in self-defense, even though he's on video stabbing this man to death and he's restrained and all those kinds of things, right? And the court just said, no, the other evidence that you didn't act in self-defense is so overwhelming that even if you had this subjective intent, the trial court didn't even err in refusing the instruction. And you could look on the Maestas rule. Granted, this is a Utah Supreme Court case from the late 70s. They're not known for really detailed reasoning and a great deal of authority that they're relying on, right?
And that was, didn't they use substantial?
Yes. And I think it's a little bit semantics, because the basic idea is there enough evidence here? You don't get it for the asking. You have to have some evidence. That's the current refrain in the case law. You need some evidence of this, right? But that is not a nothing burden. There does need to be something rather than nothing. And Maestas says that something has to be more than just a sliver compared to the rest of the evidence. So you could almost look at it like a destruction of evidence claim under the state constitution is kind of like a threshold showing, almost. It's kind of akin to that. Or you might even, another analogy that occurred to me is, it's like under State v. Virgin for preliminary hearings, the vast majority of the time, trial courts do not make credibility determinations, but there's this kind of little sliver of exception for sometimes they're able to do that depending on how it compares with the rest of the evidence. So I see it potentially as something kind of like that. And Son's testimony is contradictory because he says he acted in self-defense, but he didn't mean to. And it's all self-defense and accident mixed together, which logically are not compatible. You either meant to do it and it was justified, or it was an accident. And again, that's possible to run those under Mitchison, but to thread that needle, you need some pretty unusual facts.
So, and tell me that this is a completely irrelevant question, but does the difference in State versus Knight and Harrington versus Richter, that language difference, is this the case that it matters? Is it that the prejudice is at some point substantially short of more probable than not that the outcome would have been different, versus it does not require a showing that counsel's actions more likely than not altered the outcome? Is this the case where it matters? Or is it so likely that the result would not have been different, even if a self-defense instruction would have been provided?
This is not a close call.
Okay.
The state does not see this as a close call. Particularly where the very tall victim is shot right in the eye. And the defendant's story kept changing. And it bears notice that it went from, I have no idea, I haven't seen Steve in days, to I saw this weird guy in a construction outfit following him around in a smart car, to, yeah, it was an accident, to
I
the
took
door
him to
hit me in the
hospital.
forearm. Oh, no, it actually, after the cop said, no, it didn't, because the bullet came through the storm door. You can see it there, the bullet trajectory coming through right at the victim's eye. Oh, no, it must have hit my hand instead. So, you know he's lying because his lips are moving. And every time he speaks, there's another story. And the jury is just not going to believe. In addition to him saying it was an accident at trial, his story has changed so many times, as he himself acknowledged. It's hard to believe anybody who lies that much. And it's just not, that's why it's just not a close call at all. I'll briefly address one of your questions, Judge Mortensen. You talked about the safety or the safety features on the weapon. I won't weigh in on that debate.
Features, I'll live with it.
The answer to your question is yes, that is a reasonable cross-examination strategy. Even more so here, where defense counsel had a gun expert sitting next to him at trial, specifically to advise him on issues related to shooting and accidental discharge. Yeah, that's what I would say to that. If there are no further questions, I urge this court to affirm.
Thank you, Mr. Nielsen.
Looks like I have three points for rebuttal here, unless there's additional questions. First, I just wanted to confirm to the question about Judge Christensen-Forrester, about the ruling coming after the presentation of evidence, and that is accurate. And the sites for that are around 2735 to 40 in the record. And then second, to the point of what the state has argued about harm and whether or not Daniel would have been believable or what the jury would have believed. Again, I would just focus on the point that he gave equivocal testimony, that his statements of not remembering details, and because the verdict of murder showed that the jury rejected or did not believe that those statements, that the self-defense instruction would have mattered, and so there was harm here. And I guess maybe I only had 2 points. So if there are not any other questions from the court, we would ask the court to, or I guess the last point I would make is just to clarify that this, to some of the question, again, I think it was you, Judge Christensen-Forrester, about Knight and Harrington, just to reinforce that this first claim is not an IAC claim. This was, the district court abused its discretion, and because of that, we would ask the court to reverse. Thank you.
Thank you, Ms. Phillips-Ainscough and Mr. Nielsen, soon to be judge. We will take this matter under advisement and render a written decision as soon as we can. And thank you both for your presentation and your briefing in the matter. It was excellent and helpful, so thank you.